Johnson on AM 560. The Answer.
Top of the morning, Dan. And in for Amy this morning, Jeannie Ives, former state legislator, gubernatorial candidate, now the principal at breakthrough-ideas.com, also the host of The Real Story with Jeannie Ives on these airwaves on Sundays. Yesterday, the Supreme Court heard oral arguments in the Trump v. CASA, state of Washington, state of New Jersey cases. This is against the backdrop of Trump's executive order on birthright citizenship. But what the court is taking up is the issue of the universality of preliminary injunctions issued by federal district courts. The debate that has been raging about the scope of authority that federal district court judges have, such that it encourages forum shopping by political and policy opponents of a particular president to stop what he can, to stop or at least slow down what he can do. Maybe some cases legitimately, maybe in other cases not legitimately. But should every single federal district court judge have that sort of sweeping power, more power than the president? You know, the meme was going around. Trump decided to step down and appoint himself to be a federal district court judge, so he has more executive authority. I mean, this is the joke of it, essentially. So this was an interesting exchange between John Sauer and Sotomayor. Now, again, she starts with what she calls the clear Supreme Court precedents on the issue in the background here, which is the interpretation of the clause in the 14th Amendment that she will allege confers birthright citizenship. And thus she's saying this is so obviously unconstitutional, Trump's executive order, that how do we allow this to stand in such a way that it has to be pursued by plaintiffs with standing, and maybe you gather them into a class, but in the meantime, people are having their constitutional rights infringed upon. This is her argument. And she uses the analogy of, well, a president comes in and he says there's this terrible problem of endemic gun violence, so I'm banning gun ownership nationally. And would you have to go through that same process in order to reestablish individual Second Amendment right to self-protection among 350 million Americans? I don't think it's quite analogous, but we'll get to that. Let's hear the exchange.
The president is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
Yeah,
and you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
We are not claiming that because we're conceding that there could be an inappropriate case.
Only a class, only
Can
by
I hear
a class.
Can I hear the rest of his answer?
A Rule 23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts, in appropriate cases, may certify.
So when a new president orders that, because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then people, and he sends out the military to seize everyone's guns. We and the courts have to sit back and wait until every named plaintiff gets, or every plaintiff whose gun is taken comes into court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits. This is now fully briefed in the Ninth Circuit in case number 25-807, where we describe how that characterization of the holding of Wong Kim Ark and the other decisions is profoundly incorrect.
So there's a couple of issues there. There's the merits of the Supreme Court jurisprudence on the issue and whether or not any of those cases are exactly on point with respect to Trump's executive order. And then there's the issue that's actually at bar with the court right now, which is the universality of these federal district court injunctions, preliminary injunctions. For more on this, we're pleased to be joined by Mark Miller, senior attorney at the Pacific Legal Foundation. Mark, thanks for joining us. Appreciate it.
Great to be with you. Good morning.
Morning. How would you respond to Sotomayor's critique there and the analogy she uses with respect to a president that would come in and say, because there's gun violence in America, I'm banning individual gun ownership, and and if a federal district court can't enjoin that nationally, well, then you're going to have to file all sorts. Everybody's going to file an individual case, or you have to organize into a class. And meanwhile, Americans' constitutional rights would be violated. And so how does that make sense?
Well, I guess I'd say 2 things. There are 3 things. First, I think Mr. Sauer, the Solicitor General, did a great job of responding. 2, I applaud her for showing that this issue, cuts both ways. Nationwide injunctions have been used against Republican presidents and Democrat presidents, against Biden. Some of Biden's unconstitutional actions were blocked by nationwide injunctions, and conservatives would applaud that. But third, I agree with you that I don't think her analogy takes you where she wants to go, because as Mr. Sauer pointed out, that you can block those, first of all, with individual injunctions, just as to the individuals who sued, and then through a class action. So this idea that without nationwide injunctions, there would be nothing you could do to block unconstitutional action like seizing guns is just faulty. And it is the kind of logic that oftentimes gets sussed out in the lower courts when a case is not rushed to the Supreme Court. This case was rushed, and so some of the arguments were a little bit superficial. And I think that argument is superficial, even though I do take her point. I think she's making a good one, that this issue does cut both ways politically. Well,
that's right. Well, the other issue too is, just raising, injunction against Biden doing things like socializing student loan debt. Well, and then the president could just ignore them, and where's the Supreme Court to enforce that? But on the issue of the injunctions themselves, it seems to me, and in another exchange, I think it was with Kagan, and then Amy Coney Barrett rode to her rescue to sort of restate her positions, which is disturbing. But anyway, the idea is, Sauer said this, it's okay for things to percolate from the lower court to the high court. So if you had something like Sotomayor's hypothetical where a president banned individual gun ownership, I mean, that would make its way from a federal district court to the Supreme Court post haste. And it's much like this birthright citizenship case is much like is happening with this birthright citizenship case. So there is a way to say, if somebody is really doing something that is beyond the pale or in great controversy, well, this is why we have Supreme Court justices to exercise the good judgment to take up the issue and issue a definitive holding.
Yeah, I agree with you. In fact, there's a great example of the way they can take cases quickly. That everyone remembers, even though it feels like a lifetime ago, when Colorado, in the Trump versus Anderson case, Colorado tried to keep President Trump off the ballot for 2024. Colorado Supreme Court ruled in December, and if I recall correctly, it was about 60 days in February when the Supreme Court heard that case and very quickly ruled against what Colorado had done.
Yeah.
And so when the Supreme Court wants to take a case quickly, it can do so, and absolutely agree with you that does sort of undercut the point Justice Sotomayor is trying to make about the slowness of challenging a decision.
Well, it's interesting. I think Professor Turley pointed this out, too, that, Kagan was trying to bail water, which is why she needed Amy Coney Barrett's help, because she previously was critical of these nationwide injunctions for the exact reasons that Trump and Trump supporters are arguing today, which is they encourage forum shopping. They essentially undermine the power of the executive, and it is problematic to have political opponents of an incumbent administration running around to federal judges all over the country, just trying to get things stopped, and in many cases illegitimately so. Yeah,
I mean, Justice Gorsuch, Justice Alito, Justice Thomas, and as you said, Justice Kagan are on the record as thinking nationwide injunctions are a problem. And as you said, Kagan is sort of backpedaling, or at least appeared to be, in the oral argument. It will be interesting to see how this plays out, where you have judges on both sides, or justices on both sides of the political aisle, if you will, have agreed nationwide injunctions are abused. As Justice Thomas said yesterday, you might have that audio, he said, the nation survived into the 1960s without nationwide injunctions.
Yeah.
Why do we have to have them now? And that's, the typical practical common sense point Justice Thomas likes to make.
As a non-lawyer, can I ask a question here?
Please.
All right. I'm just a little bit confused because the arguments have largely been about this nationwide injunction issue, and this is a birthright citizenship case. So when the court comes and makes their determination, is it going to be about nationwide injunctions, or is it about birthright citizenship, or are we going to get a decision on both issues?
I think that is definitely the $64,000 question, Jeannie.
Oh.
There's really two points I can make to that. First of all, I think the justices would probably prefer, most of them anyway, not to get into the birthright citizenship question. To the extent it did come up in yesterday's argument, I don't think it looks good for President Trump. And that feeds into my other point about the nationwide injunction issue, which is, since so many justices and so many lawyers and judges generally agree that they're a bad idea in most instances, this was probably not the best case for the Trump administration to bring the nationwide injunction issue up to the court, because if ever a law needed to be blocked, a lot of people think, or executive order needed to be blocked, a lot of people think President Trump's executive order, flying in the face of 150 years of Supreme Court jurisprudence, as Justice Sotomayor tried to argue in that earlier audio clip, isn't the right case, because there's a good chance the administration is going to lose. As came up in the argument, pretty much every judge looking at this is saying you have a tough road to hoe. And so you generally want to push a case like this where you probably are right, where all of the cases on your side. Here, not so much, which isn't to say President Trump will lose on birthright citizenship, but he is arguing in the face of 150 years of precedent. And so bringing up nationwide injunctions here may not have been the wisest move.
Yeah, but
interesting to see how that plays out.
But to be fair to Trump and Sauer, I mean, if he would have brought this up in the context of a executive order renaming the Gulf of Mexico the Gulf of America, because this other executive order is hanging out there, the justices would have all had an eye towards these other executive orders. I mean, they don't. It's fun to think that they have halos on and they're very tunnel visioned on just what's in front of them, but we know that's not true.
And not only is that right, Dan, but I also agree that everything Trump does, when I say he's flying in the face of 150 years of precedent, it seems sometimes with the media, everything Trump does is the worst thing ever. So no matter what, no matter how they brought this up,
right,
the court would have been faced with the world saying, oh my gosh, this is the most horrible thing ever, even though there are examples of presidents on both sides of the aisle doing the kinds of things President Trump is doing. It's always the worst thing ever.
Well, the other issue of them issuing any sort of holding on birthright citizenship, as Sauer mentioned, it's fully briefed before the Ninth Circuit, so why would they jump the gun?
Yeah, 100% agree. And the problem for those who oppose the president on birthright citizenship is they ignore, and I'm not saying I agree with them, but the experts that support President Trump make the point that it doesn't just say if you're born here, the 14th Amendment doesn't just say if you're born here, you're a citizen. It says you're subject to the jurisdiction thereof. You're born here and subject to the jurisdiction. The question is, what does that mean? It means diplomats who have children, ambassadors who have children, they're in the state, their children are not citizens because they're not subject to the United States.
Right.
It also meant at the time that Indians, Native Americans were not subject to the United States if they left the reservation. The question becomes, how do you apply that to illegal immigrants? And that's an up for grabs question at the Supreme Court, even if it's a tough question for President Trump to win on.
Mark Miller, senior attorney at the Pacific Legal Foundation. Mark, thank you for your time and insights. Appreciate it.
Always great to be with you. Thank you.
And you joined us on the Turnkey.Pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer. Enjoy uninterrupted programming from Dan Proft and Amy Jacobson around the clock, all day, every day, including daily replays of Chicago's Morning Answer on Dan and Amy 24/7. Listen now at danandamy247.com.
Come